I'm Mark Stevens. Let's talk in this video about judicial corruption. And we get a lot of examples of this from California, of course, which is world famous for gross corruption. And this example comes from Santa Clara. And a lawyer, or the commissioner, James P. Madden, and the clerk had given him a copy of a motion to vacate denial of demur and a request for judicial notice. What I want to focus on is the request for judicial notice, because this is really easy to show gross corruption, where they just do whatever they want. They're just there to take money and to try to make it look good. And of course, here they fail, because I guess they figure no one's going to see this. So what he did was he got this. It was on July 17th, and the next day, July 18th, he issued just a standard two-word response: request denied. So the request for judicial notice, I want to bring that up. Let's take a look at that. What is he actually denying here? So if we look at the request for judicial notice, it's pretty basic. It says judicial notice of the following is mandatory. See California Evidence Code, Section 451. Well, I just happen to have that here. There we go. It's the California Evidence Code, Section 451. And it states that judicial notice shall be taken of the following. Now, when they use the word shall, that is mandatory. It is not an issue of discretion. So they shall take judicial notice of the following: the decisional, constitutional, and public statutory law of this state. This is California. You can see it's California. And also facts and propositions of generalized knowledge that are so universally known that they cannot reasonably be the subject of dispute. Now, I want to point out that the request for judicial notice, which are all the points in the request for the judicial notice, of course, were in the demur. So it just kind of put some leverage on the judge that when you deny this demur, you also have to have a blanket denial of judicial notice, which of course doesn't seem to bother them. But let's go point by point and see exactly what this James Madden, let's take a look exactly what he was actually denying judicial notice of. The first thing is the foundation of the court's jurisdiction is the purpose of American government. That's in the Declaration of Independence, that to secure these rights, governments are instituted among men. He's refusing to take judicial notice that this is true and that the purpose of the American government is to protect rights. He's denying this. He's denying that's applicable to the California government through the Enabling Act of February of 1850. Well, if you read that, it says that the Constitution of the state of California has to be consistent with the principles and tenets of the Declaration of Independence, and that just happens to be that governments are instituted among men to secure life, the rights of life, liberty, and the pursuit of happiness. So he's denying that. He's also denying that this is shown in several state constitutions, such as the Arizona Constitution, which is a direct quote, which it says that governments are established to protect and maintain individual rights. He's denying taking judicial notice of this, as if that's up for dispute, or somehow I got that wrong. Next, he is refusing to take judicial notice that standing is required because courts only adjudicate justiciable controversies. And that's the United States versus Interstate Commerce Commission, and you can verify that on a Google search. It's very easy. He's denying that this is true. Just outright denying it. Of course, he doesn't give any specific grounds because it's true. So he's ignoring the written law. They don't care. Here, we've got to have a case of controversy, or a case or cause of action. The plaintiff must plead the violation of legal right. Well, that sounds pretty standard. Anybody who's researched the law at all knows that's true. And then we have got a Supreme Court decision to back that up. And, of course, James Madden, he disagrees with this. Not going to take judicial notice of that, even though it's mandatory. Here we go. The ticket filed by the cop does not allege the violation of a legal right, nor is there an actual antagonistic assertion of rights. He's denying this. Well, you just have to read the ticket. There's nothing in there about an actual antagonistic assertion of rights. It's a traffic ticket, for heaven's sakes. This is really what takes this is really something. He's denying that the California court system is adversarial, including the Santa Clara court. That's incredible. He's denying that. So what is it, inquisitorial? There's just too much evidence out there, or at least public relations, to show that it is adversarial. So it's incredible that he is denying judicial notice that it's adversarial. Here we remember, this is right from the California Supreme Court. All I'm doing is having him take judicial notice of what this case says. In every prosecution for crime, it is necessary to establish the corpus delicti. People versus Lopez. He refused judicial notice of that. Again, he's refusing judicial notice of a California Supreme Court case. In every criminal trial, the prosecution must prove the corpus delicti, or the body of crime itself, meaning the fact of injury or harm. He's denying this. Aye. He then also denies a complaint that does not assume the honest and actual antagonistic assertion of rights to be adjudicated is unfit for adjudication. He denied that even though the United States Supreme Court said that. He's denying this. Okay, he refuses to take mandatory judicial notice of that. You see, that's called that's not just refusing to take judicial notice. That could technically be considered a crime, in that it is the obstruction of justice. And then, of course, the last one, the court's authority, jurisdiction cannot be enlarged by police authority. That's pretty, just because the cops write a ticket doesn't mean they automatically have jurisdiction over that. So here we've got 11 very clear examples of where he should have taken judicial notice, because under his own statute. And don't have me come down after you either. There you go. A little Frank Rizzo there. Under the California Evidence Code, Section 451, judicial notice shall be taken. And, of course, he refused to do that. And it's no surprise, of course, he gave no grounds whatsoever, because there aren't any grounds. He refused to take mandatory judicial notice because he doesn't give a damn. He doesn't care. These judges, commissioners only are interested in taking your money. They don't care how it looks. They don't care. They don't care. You're not going to, if you have any intention of getting justice by walking into this guy's court, you're stepping in on the wrong foot. It's a public relations scam. They're all criminals. They don't care. How else could he justify, or how else can you explain why he won't take mandatory judicial notice of such basic things as the California court system being adversarial? Of course, they're criminals.